Hello, everyone. Welcome. Thank you for tuning in to today's Friday Forum. My name is Audrey Stewart, and on behalf of Harvard Bookstore, I am so excited to welcome you to today's event with Brandon L. Garrett discussing his new book, Autopsy of a Crime Lab, Exposing the Flaws in Forensics. He is joined today in conversation by Daniel Medwed and Radha Natarajan. Harvard Bookstore's Friday Forum takes place on Friday afternoons during the academic year as a way to highlight scholarly books in a wide range of fields. Through virtual events like today's, Harvard Bookstore continues to bring authors and their work to our digital community during these challenging times. Every week, we're hosting events here on Zoom, and as always, our event schedule appears on our website at harvard.com/events, where you can also sign up for our email newsletter and browse our shelves from home. Today's discussion will conclude with some time for your questions. If you have a question at any time during the chat, go to the Q&A button on your screen and we'll get through as many as time allows. If you would like to purchase a copy of Autopsy of a Crime Lab, there will be a link in the chat where you can purchase. All sales through this link support Harvard Bookstore, so thank you, especially during this difficult time for community spaces like your local bookstore. There will also be a link for donation in the chat if you would like to give additional support to Harvard Bookstore. Your purchases and financial contributions make this virtual author series possible, and now more than ever supports the future of a landmark independent bookstore. Thank you so much for tuning in support of our authors and the incredible staff of booksellers at Harvard Bookstore. We sincerely appreciate your support now and always. And as you may have experienced in virtual gatherings this past year, technical issues may arise. If they do, we'll do our best to resolve them as quickly as we can. Thank you in advance for your patience and understanding. Now I am so excited to introduce today's speakers. Brandon L. Garrett is the L. Neil Williams Professor of Law at Duke School of Law, where he directs the Wilson Center for Science and Justice. His previous books include Convicting the Innocent, When Criminal Persecutions Go Wrong, Too Big to Jail, How Persecutors Comprise the Corruptions, and End of Its Rope, How Killing the Death Penalty Can Revive the Criminal Justice. He is joined today by Radha Natarajan. Radha is the executive director of the New England Innocence Project. Radha spent 12 years as a public defender, most recently at the Roxbury Defenders, handling serious felony cases in the Massachusetts trial courts. She is the recipient of the 2020 Carol Donovan Award for Exceptional Advocacy by the Committee for Public Counsel Services and the 2020 Excellence in the Law Award for Massachusetts Lawyers Weekly, among other awards. He is also joined by Daniel Medwed. Daniel is the University Distinguished Professor of Law and Criminal Justice at Northeastern. He is the author of Prosecution Complex, America's Race to Convict and Its Impact on the Innocent. He is a founding member of the Innocence Network and consortium of innocence projects throughout the world. He is also the legal analyst for WGBH News. Today, they are here to discuss Autopsy of a Crime Lab. It's a devastating forensics takedown, which takes us into the lives of the wrongfully convicted or nearly convicted, into crime labs rocked by scandal, and onto the front lines of promising reform efforts driven by professionals and researchers alike. Autopsy of a Crime Lab illustrates the persistence and pertinence of shaky science and its well-meaning practitioners. Amanda Knox called it necessary reading. She says, Garrett breaks the illusion that a white lab coat shields a person from bias and that a sterile work environment necessarily produces cold, incorruptible conclusions. And on that note of praise, I'll turn things over to our authors. Brandon, Radha, Daniel, thank you so much for joining us. I'm really excited to have you all here.
Thank you so much. That was a really lovely introduction to all of us. And I'd forgotten how eloquent that quote was from Amanda Knox that she shared about the book. And it was really a privilege to be able to tell some of the stories of people like Amanda and others whose lives were altered for the worse by the types of tragic errors and miscarriages of justice that occur because we have such an unregulated and unscientific system of forensics in this country. Although I guess I'm the featured author, I really was hoping we could start with Radha and Dan, particularly to talk about how pressing this issue is in Massachusetts. one of the key chapters of my book talks about the Massachusetts crime lab scandals, but they know much more about it than despite the storytelling and digging that I did. They've worked on these issues firsthand in Massachusetts. And then I was thinking that Radha could talk and Dan could talk, and then I would step back and talk about the book a little bit too. And we'd love to take your questions. We hope you direct questions to all three of us. We want to have a conversation. I didn't want this to be like an author meets readers. I'd like us all, because so many of us are working on these issues, to all talk collaboratively about this. So we'll try to keep our presentation short, and we really look forward to all of your questions in the chat. So I'd like to turn things over to you, Radha.
Thanks, Brandon. Thank you for inviting me. And also, it's great to see so many people here. If you're not going to plug the book right off the bat, let me just say, from my perspective, that everyone should read the book. It should be required reading in law school. It should be required reading for everyone involved in the criminal legal system. And I will tell you that I absolutely wish that I had this book when I began my career as a public defender 18 years ago. And honestly, I don't know, it's almost like hard to imagine all the things that I did without the information in this book. And I'll tell you about at least one case, a Massachusetts case, that I think flows from that knowledge or lack of knowledge. But I wanted to just give a few comments on, the book itself, and sort of to give you the framework for both what it does and what it tries to do. It exposes things that are frankly very difficult for people to accept. We believe, we accept, we think that it's easy to solve a crime, and that the methods that we have resorted to in the criminal legal system to find answers or truth, we believe that those methods are reliable. And I think that that makes sense, because human beings want to have answers, they want to have certainty, and it's really, really hard to believe that this system can't produce those answers. In fact, the entire criminal legal system is built on the idea that there is a way to find the truth. And it's uncomfortable to know that as we're trying so hard to find that truth, we've actually been grasping at unreliable methods, which have led to significant harm and injustice. And I think this book, it catalogs in every domain how we've grasped at these straws to find answers. And it makes sense that we want to find those answers. But what we've done in that service has been really fraught with a lot of harm. And I want to say that, I say everyone should read this, and I also want to say that we don't want to believe the truths in this book. We don't want to believe that getting things wrong happens more than we know. We don't want to go back and acknowledge our mistakes, and especially not at this scale. But we have to. And I think this book has a roadmap for that change. And there are examples in the book of people doing that hard work. And so there is examples there of how it can be done and why it should be done. And so as a community, right, this is a community bookstore. And I think it's important for us as a community to say, we are going to demand more from a system that takes away lives and freedom. And in the end, that is what the book is about. It is actually about freedom. And so that's just sort of like my overall, but I mentioned at the beginning, I wish I had known some of the things that are in this book when I started as a public defender. That was a long time ago, but even as an innocence lawyer, right? That's my job 5 years ago. And now I think people know that bite mark comparison sort of has this bad reputation. People sort of know its unreliability. But when I started, I didn't know that. And my first examination, or my first learning of it being so unreliable, was literally looking up, as Brandon talks about, every single court in the country has deemed this evidence reliable, the highest court. And when I looked at our own case law in Massachusetts and found the case that says this evidence is reliable, and then I looked and I found that that man whose case that was still in prison. And I was shocked. And then I went and met that man, and through DNA evidence and a collaboration with a pro bono team from Ropes and Gray, we demonstrated not only that he was innocent, but we were able to demonstrate who committed that crime. He spent 35 years in prison, innocent, solely based on bite mark comparison evidence. And what is so incredible about it that you may not know is that, so his is in the law, we say the precedent setting case, right? It is cemented in our law now that this evidence is reliable based on his case. And even though he's been exonerated, which demonstrates, among science, of course, it demonstrates the unreliability of it, his case remains that way. And it sets the precedent, not just for bite mark comparisons, but for all other forensic evidence. So there's not even a mechanism in the law for all these truths and all these tragedies and all these exonerations to go back and fix the precedent. We don't even have that. And so I guess one of the things that I'll mention, and I want to turn to Dan, I know he's going to be talking about some other aspects, but one is that, we really need to think about, precedent, which, cements things in the past, and science, which is revealing things in real time, and how we need to marry that, and how it's not just, it is essential for us to do our work for that to happen. And so I think we'll talk about maybe a little bit later about some of the things, some of the reforms and other things that we're doing here. But I just want to thank you, Brandon, for bringing this book. It is like 18 years too late for me, but I'm so grateful that you wrote this book, and I hope that everybody reads it. There's so much to learn from it.
Thank you, Radha. And Brandon, thank you so much for inviting us. It's a pleasure to be here with two of my favorite people, Radha and Brandon, and special thanks and shout out to the Harvard Bookstore crew, an amazing, amazing bookstore right here in Harvard Square. As Brandon and Radha well know, forensic scientists often like to talk about the gold standard of particular disciplines. Fingerprinting for a long time was the gold standard until several people were wrongfully convicted, including a man in Boston, Stephen Cowens, based on flawed fingerprint evidence. And even DNA, there have been about 9 or 10, Brandon would know better and Radha would know better than I do, DNA cases where it was botched on the front end and the wrong guy was convicted based on DNA evidence. But there is one thing that really does measure up to the gold standard, and that's Brandon Garrett himself. He is the gold standard in our field, and he has been for nearly 20 years, 15 years, right, Brandon?
Here, I was going to say, I was like, I should have used the gold standard metaphor in my book because it's a flawed metaphor. We don't follow the gold standard. We should have an empirically validated, dollar value, which we kind of do. Markets, so I was hoping we go there and say we shouldn't be using a discredited concept for what counts as making something good, like based on its association with a precious metal. Anyway.
So as usual, as usual, Brandon has taken one of my superficial metaphors and deconstructed it in about 3 seconds, which is I've been taken down in that fashion many times by Brandon in the past. So that's very on brand, Brandon. On Brandon. That should be a new term. What do you think, Radha? And Brandon really is sort of the go-to person in our field. And what he does, and for those of you, I urge all of you, regardless of your familiarity with criminal justice, to read this book, because what Brandon does, I think, better than almost every scholar out there, is he takes sophisticated empirical evidence and data, and he makes it accessible through lively prose. And he's done this time and time again in the books that Audrey mentioned in the intro, especially, I think, in Convicting the Innocent, which is a 2011 book, right, Brandon, that really analyzes wrongful convictions, the DNA exoneration data set. So Brandon, congratulations on another a part of your canon. There are a couple themes in the book I just want to emphasize very briefly before we turn things back to Brandon and open things up. What Brandon does here that I think is very effective is he shows sort of the cross-contamination of various aspects of forensic evidence and how they can lead to wrongful convictions. And there really are three overarching variables. So first, you have flaws in the science itself. And Radha mentioned this, bite mark evidence is fundamentally flawed. Bite mark evidence is the idea that when somebody bites into a malleable surface like skin, it will leave a fixed dental impression of the person's teeth. Well, that's sort of absurd because the skin will adapt and change in response to that indentation. But yet it has been involved, I think, in 25 documented innocence cases at least. Maybe my numbers are a little bit off. The second thing he does that's really important to realize is how the setup and structure of forensic labs, of crime labs, which are typically affiliated and run by the state, how that aggravates some of the dormant flaws in the science by making it very hard for people like Radha and other dedicated innocence lawyers to get access to underlying evidence that could allow us to figure out what those flaws are. And that is one of the reasons why we've had two major crime lab scandals here, drug crime lab scandals, one in Jamaica Plain and one in Amherst that we can talk about during the Q&A. And the third thing that Brandon does, and he's done in a lot of his work, is he shows how the court procedures themselves can aggravate this even more. You have judges who are reluctant to keep out poor science. They are reluctant to do this for a couple of reasons. One is that the evidence rules surrounding the admissibility of scientific evidence are very deferential to the scientists themselves. This might be going into the weeds too much, but there was a test called the Fry test, and now there's a modern test called the Daubert test, both of which really defer a lot to what the generally accepted science is. And basically you have the fox watching the hen house. If bite mark, forensic odontologists, that's their official phrase, if bite mark experts say that a particular technique is legit, judges will often defer to it and let it in. But of course, those experts who are unregulated largely have a self-interest in saying that their methodology is legitimate. Then you have prosecutors who often double down on this evidence at trial, and they overstate the significance of it during closing arguments. You have expert witnesses who, as Brandon has done an amazing, really since your 2009 article, I think with Peter, Brandon, in the Virginia Law Review, explored how prosecutors often overstate the extent of their findings. They'll say there's a match between two hairs when at best they can say that the hairs resemble one another, right? And then finally, you have jurors who, and this goes to Amanda Knox's observation about Brandon's book, you have jurors who are overwhelmed, who are wowed by the mystique of the white coat. Many of us, I mean, I'm not very good at math. My mom would be much happier if I were a doctor. Mom, if you're listening, I hope you're chuckling. But I'm not good at math. So I defer to anyone who has scientific or mathematical knowledge. I'm not able to really critically examine it. And a lot of jurors, I think, are in the same position when it comes to expert witnesses. So those are just some of the broad themes in Brandon's book, and we can talk more about Massachusetts later, but I didn't want to take up too much airtime from Brandon.
Well, thanks. I really don't want to take up too much airtime either, and because I want us all to talk. But it's really a treat to be back here. When I last published a book, it's actually, wait a minute, it's hard to do there it is. End of Its Rope was a book documenting and doing statistical analysis of the decline in death sentencing in this country. I presented it in person upstairs at the Harvard bookstore, and it was a treat to be there in person, and we can't do that right now. And so I'm grateful to be back at the Harvard bookstore, even if it's virtual. One thing that's not Harvard about my new book is that my first 3 books were published by Harvard University Press. This book is published by California University Press, and they've been wonderful. It's been really interesting to work with them. I tried to write a shorter book this time, and so far the granddads in my family seem to appreciate that the chapters are a little bit less technical and are a little bit punchier. I certainly, I should have read this book, when I was starting out too. When I was beginning my work representing people who had been exonerated, I certainly knew that, DNA testing set them free, and sort of was a champion of the role that forensic science could play in identifying errors that never would have come to light before. And so I was in somewhat of a go forensics mentality. But then as I began to dig into those cases systematically, I saw how many of those cases involved flawed forensics and evidence presented by experts in really confident terms that was really powerful to jurors, and that was flawed and that was wrong. But even there, a lot of those DNA cases involved murders and sexual assaults, where a lot of the evidence was hair evidence, blood typing, bite mark. And you can even, I think a lot of people have now seen coverage of the Massachusetts scandals. And there's this conception that, okay, you have some corrupt lab analysts, bad apples here and there, who are not even testing the drugs, using the drugs themselves. They're addicted. It's really tragic that they fell apart and did such terrible work. And maybe there's some techniques where we now know that there's just so much unreliability surrounding the comparison of hairs that maybe we never should have used it in the first place. Or like the FBI bullet lead analysis. The FBI stopped using it after the National Academy of Sciences dug in and said, there's just no there. This isn't a reliable method. But certainly I never thought that there would be serious concerns about fingerprint work, firearms comparison work. That kind of work is the bread and butter of what a lot of labs do. If you think about our crime labs in this country, about half of what they do is not connecting evidence to individuals, is large-scale chemical testing assays, testing blood alcohol levels, drug testing. And then the other half, in terms of connecting evidence to individuals, the bulk of that is fingerprints and firearms. And why it is that so many people who commit serious offenses don't wear gloves and there's so many latent fingerprints found at crime scenes, well, there's still a lot of fingerprints found. There's often a lot of both, actually, fingerprints on guns and looking at the, anyway. And when I started doing large-scale mock jury studies and surveying, at this point, it's been tens of thousands of lay people that I've surveyed in terms of their attitude towards forensic evidence. Some very simple things jump out of these studies, sort of too simple to report in peer-reviewed journals for the most part, but everyone thinks that fingerprint evidence is unique. Everyone thinks it's incredibly strong. We have, in experiments, you have controls. And so often there'll be some condition in a study where there'll be a scenario and, there's some evidence at a convenience store. We want to keep it simple so they're not focused on the personalities of the detective or the person. And they'll be basically like a convenience store was robbed. The police got a guy. The print was identified by the expert as having come from the defendant. That is enough for lots of people to convict someone for that robbery. Police got a guy, there's a print. Doesn't matter what the expert says in terms of how strong their conclusion is or what words they use. Basically, when we've surveyed these thousands of people across the country, different age groups, different educational backgrounds, basically you hear arrest plus fingerprint, golden. And that's true for other disciplines. We now know so much more about how errors can happen. And the reason why it's kind of gross to think about an autopsy for those of us who are lawyers and didn't become doctors. But the reason why I titled the book the way I did was that the idea is to take apart from front to back all the different ways errors can happen. And so it's not even just that you can have a method where we don't know what the method is, where people are just kind of looking at bite marks and not necessarily making measurements, and we worry that subjectivity can play a role. Everything that happens from the crime scene to the lab to the courtroom can involve error. And in the past, it has often just been wholly unregulated. And we take at face value that if someone says they're an expert because they've been doing something for a while, then they're an expert. There are enormous problems at the crime scene where you have untrained police officers collecting evidence. And, in huge numbers of cases, you have evidence that's unusable and that could be used to prove innocence or guilt, and it just can't be used. I did a study with some wonderful examiners at the Houston Crime Lab, Houston Forensic Science Center now, and just the percentage of their cases in which the fingerprints were just wholly unusable was stunning. Now, sometimes that's because, it's one of the challenges in fingerprint work. You know, when you get asked to roll your prints for a job or a passport or something, they ask you to just carefully roll from left to right. They may ask you to do it over because they didn't get a good print. Some people's fingers don't leave good prints. Well, obviously someone who's committing a crime isn't trying to carefully roll their fingertips and leave a really good print. So there's just a lot of incomplete evidence that you can't do much with. But that's not something that people understand. They assume that prints, they're so detailed, there must be great evidence. This must be really, really powerful evidence. They don't realize what low quality a lot of what gets left at a crime scene is. It's what makes forensics work really, really challenging. But it gets magnified when you have people collecting the evidence who do a terrible job. And that's just the most common complaint when you talk to crime lab directors, is that untrained law enforcement, just at the moment the case begins. That was true in Amanda Knox's case and in other high profile cases. You have crime scenes that are contaminated through sloppy investigation because you have officers who aren't trained. They don't have a research background. And, you know, when we talk about, there's an op-ed I've been working on with the head of the president, the CEO of the Houston lab, that if you talk about funding or defunding the police, well, if we want serious crimes to be solved, we need, from the CSI stage at the crime scene, we need it to be independent of law enforcement. We also need the work in the lab to be independent of law enforcement, because even if you have someone who's well trained, who's looking at good information, a really detailed, you know, latent fingerprint, for example, there's the role that bias plays in their analyses. That's not something that we think about. We assume that experts like wear white lab coats and they're independent, they're researchers kind of, or they're scientists. My friend and partner in the Houston misdemeanor bail monitorship, Sandy Garrett Thompson, has a wonderful book called Cops and Lab Coats, capturing this idea that we don't want forensic examiners to feel like they work for the police, but that's typically how it is. Their agency budgets are set by the police. They're talking to detectives. Even colleagues of mine did a wonderful study just looking at the forms that are used to submit evidence to crime labs. And often just those forms call for all kinds of biasing information. There's no reason, for example, that when you're looking at the fingerprints on a screen, you need to know that the guy has a long criminal record versus a short criminal record. You need to be looking at the patterns. There's also bias often built into the processes that forensic examiners use. So I talk a lot about the most well-known in the US fingerprint error. There've been lots of high-profile fingerprint errors around the world, but the Brandon Mayfield case is the one that really hit home in the United States because it was such a high-profile terror organization. And one of the problems was, there are many problems. They knew that their suspect was Muslim, and that may have caused them to think, he must be a terrorist. But they also looked at the fingerprint side by side, and that can cause circular reasoning, where if you're looking at things side by side, then you may start to see things in common in the same way where you see someone walk with their dog every day, you think they look like their pet, or you see couples walk together and you think they look alike. Sometimes they do start to wear the same clothes. That's a different kind of bias, but looking at things side by side can distort your perceptions. That's why the FBI, after that terrible error where they falsely arrested someone for material support of terrorism in the Madrid train bombing, he never even been to Spain. They decided that, okay, we need to go sequentially. We look at the latent print, we mark it up, we study its detail. Only then do we look at potential suspect prints. So there's bias built into the process. There's bias built into assumptions that this person must be guilty. We know he confessed, the police told us. And there's also a confirmation bias built into the role where in their regular jobs in so many labs, examiners never get told when they make errors. They never find out. They have no way of knowing. They will testify. I've worked on thousands, tens of thousands, hundreds of thousands of cases. I've never been wrong. My personal zero rate is 0. Are they tested? The Houston Forensic Science Center now routinely does blind testing. So there are cases that they work on which are a test. And that way they get told when they make mistakes. And there's a culture that we know that errors happen. We know that any human being is fallible. We need to catch those mistakes in cases where it doesn't matter, where it is a test, so that we can solve these problems. And in what profession are people allowed to just go around assuming that they are perfect, that mistakes are impossible, and therefore we don't need to look for them? Like, who does that? Well, forensic examiners had done that for decades. They would claim infallibility in court. They would claim a 0 error rate. It was all laughable. They were never tested. And everyone, it would be a national scandal if at the TSA they said, we hire people to, look for bombs in airport screening. What we do is we give them a couple of years experience looking for bombs, and then we just let them do it. And we just, they're good at studying those patterns and looking at the screens, and you've seen those screens, they're all different colors and layers, and it's hard to interpret patterns. It's like looking at fingerprint images all day on screens. We don't test them. We just assume based on their experience that they're really good bomb detectors. And we just let them go for it. That would be a national scandal. And in fact, they do test them. They send through fake bombs. And there have been issues where fake or real bombs that they send through as proficiency tests, they don't catch them. And so they do retraining. They figure out what the problem is. Same thing with cancer screening labs. Clinical laboratories are subject to serious federal regulations in this country, because you don't have someone say, oh, I'm just really good at detecting cancer, trust me. They test them. But in our labs, we let people come into court saying, I'm based on my training, experience, and judgment, I can conclude that these two things came from the same source. No statistics, just based on my gut. They don't say it's just based on my gut, it's just my opinion. They're now moving towards some more cautious statements. Well, it's my decision based on my experience and training and judgment, and I've never been wrong, and I have a 0 error rate. And the only error that's ever happened in forensics is the Brandon Mayfield error or something like that. So I talk in my book also about the problems with our judiciary, that judges have fallen down on the job, that they're supposed to be gatekeepers. They're supposed to be examining reliability. I don't think that experts should even be qualified as experts unless there is objective evidence of their expertise, unless they've been given serious proficiency tests. Anyway, I don't want to get too in the weeds in all the ways that forensics can go wrong, but I want to convey that it's not just about error rates. It's not just about methods. It's not just about quality control at labs. It's not just about bad apples, because, why did no one catch that Annie Dukem was doing all the drugs and not testing it? Why did prosecutors favor her work? Because she was so efficient. Why, in other states, when there have been similar scandals, have judges not reopened tens of thousands of cases? Why have judges asked so few questions about reliability? Why don't we ask whether, if a technique involves the judgment of a particular expert, we need to know how good is this expert, not just how good is bite mark in general, how good is fingerprint evidence in general, how good is this fingerprint expert? We need to know how good individual examiners are, because the whole technique involves the subjective judgment of individual people. And we're not doing any of that. And it's been a slow-moving national crisis. We've known about this for years. We've had leading scientific organizations step in and say, enough is enough. This is not science. This is problematic. And the response has often been, well, hold a commission, some more funding for research, which is good. And it's, the research community has benefited and has done more in recent years. But there seems to be no rush. When you compare how much work went into developing accurate tests and improving the tests and testing the tests for COVID, when lives were at stake and it was a national pandemic, we are capable of doing incredible things in this country, and rolling out sophisticated testing programs and vetting it and ensuring accuracy and improving upon that accuracy when we believe that there are great stakes. And we can do that for a fraction of the cost in forensics. And nor is our sort of laissez-faire attitude towards science in our courtrooms cost-free. It's been enormously expensive to compensate people for the years they spent in prison for crimes they did not commit. One of the impetus for the top to bottom changes in Houston was that in Harris County, there were a number of exonerations. They paid out tens of millions of dollars in civil rights litigation to people who lost the best years of their lives due to forensic errors. And it's easy to make that cost-benefit decision when years later you see what you have to pay to unwind these horrible errors. Guilty people go free, innocent people spend time in prison. Also, enormous numbers of crimes just go unsolved because evidence is just wholly contaminated. So, I think that addressing these problems begins with just addressing this fundamental misconception that I shared as a young lawyer, we all shared, that there's this perfect forensic match that people can make. That actually, just like on TV, experts can walk into a courtroom and say, I looked at it, it's a match. That's one way that these CSI shows are actually kind of accurate. Just like the leather jacketed, I guess I am wearing a leather jacket. The guys on these shows, but just dressed much better and cooler than I am. They swagger into court and say, we did this technology, we did this thing, that this minute piece of evidence shows that guy that no one suspected did it. There's some truth to that, in that these crime lab staff have been accustomed for years into coming into court and claiming that they can make a perfect match, when it's, they have sometimes quite good information that they're working with, But like anything that is done by whether it's a machine or a human, there is uncertainty, and you have to measure it and you have to disclose it. And instead, there's been this myth of an infallible, perfect match in our culture. We've been told this for decades, that you can perfectly match a fingerprint, you can perfectly match a firearm. That needs to go. When you give people real information about the strengths and limitations of evidence, we can make reasonable decisions about it. That's why we have juries in this country. It's also why we have judges who can make decisions about, is this person an expert? Can they say enough to be useful in court? We can do all this. It's not that hard. It's not that tall a lift. And we look carefully at evidence in lots of situations, particularly in civil cases where people's lives and liberty don't hang in the balance. We should be doing it in criminal cases. We can do it. And it's been exciting to see so many criminal legal system failures lifted in the past year. I hope that as part of the larger discussions about how to improve our system of justice, that we also look at what evidence we use, because it goes sort of fundamentally to how we decide who should be convicted and for what in this country. And so I'll stop there. It's really, again, a pleasure to be back at the Harvard Bookstore and to be here with Radha and Dan. And I see we have some questions, and so I'd love for us to start interacting with you all. And thank you all for joining us and sharing your Friday lunch hour with us.
All right, we do have a lot of great questions. I'm gonna just get started, and feel free to, anyone who wants to answer, go ahead and answer. This is from Michael Meltzner. Almost 20 years ago, an eminent federal judge, Lou Pollock, ruled that fingerprints evidence failed to meet the standards of scientific evidence. What's the situation today with challenges to fingerprint evidence?
Yeah, and that case is, I talk about the case at the very beginning of the chapter on the role of judges, because it was such a disappointing decision and so emblematic of what judges have done. A lot of lawyers figured that things changed fundamentally in 1993 when the US Supreme Court decided this Daubert decision. And the quick version of it, Dan was talking about a little bit, is that no longer do judges let in a technique because it's generally accepted within a particular community. Because the danger is you could have a community of astrologers who all generally accept that if you look at someone's palm and look at the lines, you can tell how long someone lives. And so instead, you need to know whether that's reliable. And so you need to know whether there's research on that topic, whether there are error rates, or whether people have measured the limitations of this discipline. And you don't just look narrowly, and you don't only scrutinize novel evidence, you scrutinize any method where someone says that they're an expert and they're going to come into court. And we let experts do things that no other witness can do. Experts are allowed to give opinions. A regular witness can't say, oh, it's totally my opinion that guy's guilty. Experts are allowed to form opinions, but we only let them do that in our courtrooms because supposedly they're basing it on research and not just based on their own opinion. And that's the concern, is that, wait a minute, are we letting them just give opinions in criminal cases? We don't let people do that. Well, people thought that, okay, now judges are going to look more carefully at forensics, which have never had, some of these techniques have never had any research done on them. It's just sort of a tradition of people looking at these images and saying, oh yeah, they came from the same source. Well, Judge Lou Pollock was, a former Yale Law School dean, like no, shrinking violet, very respected judge, and held really, detailed hearings ultimately on whether the fingerprinting discipline satisfied Daubert. His initial ruling, based on a substantial record assembled in a different federal case, was, I don't see it. The FBI is coming in once again saying zero error rate. You can't make mistakes in fingerprinting. You just can't. We're perfect. And he was like, what's the research? What's the evidence of this? I don't see it. They don't meaningfully test these people to find out whether they make mistakes in their daily jobs without serious proficiency testing. Someone from Scotland Yard came in and said, we would fall about laughing in the UK if this is how you were tested in terms of quality control. Well, all hell broke loose when he issued that opinion in this case called the Yarrow Plaza. And the FBI said, you've misunderstood us. We need more hearings. We'll present more witnesses. You need to listen to us. You're missing the full picture here. And so the judge holds these hearings. Sure, I'll hear you out. And ultimately, months later reverses himself and basically says, I still think that there are these problems. I'm not convinced that this is reliable. We don't have enough evidence, but ultimately kind of wimps out and says, well, there are these challenges. There isn't proficiency testing. We don't know how reliable any given expert is. I'm still very concerned about all of this, but we can let lawyers bring that out in court, and just educate the jurors on it. And ultimately, every other federal court went the same way and has said that fingerprinting gets in because maybe there's not a zero error rate, but we don't know, and the error rates must be very small. Well, now some of the first studies have been done looking at error rates in disciplines like fingerprinting, and they are not zero, and they're not nearly as small as people assume. It's like 1 in many millions. These error rate studies are showing errors that can be shockingly common, and errors of different types, and they're not even looking at forensic issues of bias and all the other things that can change experts' minds about ambiguous evidence. So that's been true for other disciplines. In recent years, we've started to see judges dig in more in certain areas, like in firearms cases. Some judges have also been willing, okay, we're not going to question the method itself, but how about the work that this examiner did? Did this person document the work? How long did they spend on it? What did they do? If we don't know, maybe there's an issue of reliability as applied in terms of what this expert did. We've seen judges start to dig in there. I think slowly there's been some more judicial awareness that they've been rubber stamping stuff of totally unknown reliability, and that's an embarrassment to the judiciary since they're supposed to be the reliability gatekeepers. But like Radha was talking about, it's a precedent-bound system. And so if there's an opinion from 50 years ago where a judge said, fingerprinting, it gets in, it's been around for a while, even under new rules, even under Daubert, even if a state passes a new evidentiary rule, judges often look to the old opinion and say, I don't know, there's an old opinion, that's fine.
I think if I can step in, Brandon, here at this pause, I think this story, it's not a story. It's the history in terms of this judge. I think it shows us something sort of bigger. And I think it goes to some of the other questions that are in the chat about the role of the judiciary or why things haven't changed. And I think, there's two ways to look at it. You can certainly say it has to do with sort of a fundamental misunderstanding about science and sort of how lawyers are administrating the system, but don't understand all these principles of like how things can be unreliable, for so many different things, including cognitive bias by experts and all of that. But I think that that's only part of the story. So that may be true. That certainly, is true. We are not taught these things in law school, and we then, go out and be defense attorneys and prosecutors and judges. But I think that when you look at civil cases, and you mentioned this, civil cases where money is at stake, where different people are the litigants, the same judges actually can apply science. Maybe it's not perfect, maybe they don't understand all the things, but do they look at it, are they able to look at it with more rigor? And I think that the part of the reason has to do with this very story. It's emblematic of, in order to find that a forensic technique is unreliable, the court has to actually stand up to law enforcement. And I think that that's a really important dynamic and a power dynamic that, really is underlying all of this, the foundation of this. Who are the victims of the criminal legal system? Who is the victim when somebody is wrongfully convicted? Who are the people in the criminal system? Who are the people charged? And does the judge feel that those stakes matter, as opposed to when there are civil cases and there are different litigants? And I think that both race and the role of law enforcement in forensics, the role of law enforcement in terms of the power in the courtroom, I think really it explains a lot of, like, you can change it from Fry to Daubert, or you can call it another case, you can use another test, you can make it more rigorous, but the judges have to apply it. It's not about whether the test is more rigorous. It's about, can you actually stand up and say, I'm not admitting fingerprints anymore. I know it's been done, but I'm not going to do it unless you prove it. Will someone have the courage to say that? And I think that the question of, do you have the courage? We have a lot of data on how it's not reliable. and a lot of research. And we have enough research to know that freedom should not be decided by these methods. So that's actually not, yeah, we can always do more and it's great to learn more, but I think really it requires a completely different way of approaching it. And I think that in order to be able to have that courage, there has to be a movement of people, a community that makes it okay for a judge to do that without it being the front page of the news that now this judge is letting criminals go free, right? So that's sort of the way the media, the public plays into all of this. And I think that's why it's so important that folks are here and that people can read this book, because it is very accessible to even people who are not part of the system. So I just wanted to offer those thoughts.
I've been shocked how few judges have even done things that don't involve excluding the evidence, but like what Judge Gertner did when she was on the bench and said, look, every time there's a forensic expert, we're going to have a hearing on it. You need to share all the underlying documents with me, all the discovery. I'm not going to just look at a one-page report and say, oh, we have expert evidence here, take the stand. Just standing orders to make sure that there's clear disclosure on all the work that was done by a forensics examiner. So many judges don't even have hearings to look into reliability. And so there's really just like this head in the sand approach, which may reflect that lawyers don't have much of a science background. And I certainly don't. And also, I quote Judge Jed Rakoff, who talked really candidly about some of these issues at a conference I organized a few years ago. He's like, a lot of us are former prosecutors. That's a lot of what the bench is judges who are former prosecutors. And we all put these experts on the stand ourselves. And so it's a little hard, it's a little kind of cognitively dissonant for us to think that there's anything to even ask about. Like, we know these methods, we put them on the stand and we've walked through it before. It's a little hard for us to wrap our minds around the idea that there could be anything at all wrong with putting on experts that we ourselves put on hundreds of times back when we were baby prosecutors.
All right, we have a question from Jennifer. Although it's been more widely acknowledged that the reliability of different types of forensic evidence is suspect and has poor scientific underpinnings, courts still accept this type of evidence and juries appear to give it great weight. So how to change this paradigm and encourage more judicial scrutiny of suspect science?
Great, I'll jump in for a second if that's okay, guys, because this follows really nicely from what Brandon and Radha were just talking about. It's a great question. I've always thought that more heads are better than one. And the idea of putting all of this responsibility on the judge is a big ask. Radha's point about civil cases is so important. That is really, really important. Why are judges willing to do this more carefully and rigorously in the civil context? Could it be race-based, class-based? I think those are big variables. And I'm glad, Radha, that you highlighted that, because it's so important. One thing that I've always been a champion for is the idea of having a group make this decision. So the rules of evidence, there's a rule, I'll just show off a little bit here. It's Rule 706 that allows judges to appoint independent experts to help with the reliability assessment of forensic evidence or other types of evidence. But Brandon and Radha, I don't know a criminal case where judges have ever used 706 and actually appointed objective, independent experts to help with the evaluation. So going to Jennifer Kamarowski's great question.
It's really rare,
yeah. We could just encourage judges to do that because the dynamics of group thinking really can help thwart some of the pernicious cognitive biases that a single judge might have, and it forces people to be a little bit more circumspect. I don't know what you guys think. Is that a partial solution? I don't know.
I mean, I think there's a problem, which is that people who do work in some of these disciplines only work at law enforcement crime labs. And unless you find someone who's retired,
you could be an expert. Come on.
And
so with Radha too.
I mean, a minimum, right? You have, especially in the state courts, the defense never gets their own expert funding, and so you need someone else to look at the evidence. There's a battle of the experts study I just did with my longtime collaborator, psychologist and law professor Greg Mitchell, and what we found is that even having a defense expert who didn't look at, say, the fingerprints, but they just talk about the strengths and limitations of the method. They walk the jury through, this is the method, this is what we know about error rates. This is not a perfect match type method, but there certainly can be strong fingerprint evidence. This is how it works. Having just someone else explain all of that had a huge impact on jurors in our mock jury studies. Just having a methods expert. So actually, it could be someone who isn't, someone who works at a crime lab. It could be someone talking about cognitive bias. How the expert that you just heard from heard all this biasing information. They may not know that it unconsciously affected them, but we know from research that it can. A methods expert can have a huge impact, but often judges would be like, why is that relevant? The only relevant thing is the person who looked at the prints. And that person was an unbiased person from a crime lab. Why would you need a duplicate expert? Well, we actually know that not only even in fingerprinting, not only might two different experts come to different conclusions, but there's been powerful research, including an FBI study, showing that you give the same fingerprints to the same expert 6 months later, and they may not come to a different conclusion. Sometimes they do. They'll also rely on different markers. They'll do their work in a different way. There are real questions about repeatability and consistency, even within the mind of the same examiner. And so, yeah, having someone else look at the evidence, really powerful. Having someone independent look at the evidence, really powerful. But the final concern, though, is that with the problematic ways that some of these fields work right now, I mean, there's a case of Stephen Cowan's in Boston, where it turns out, like there's later an inquiry, like the fingerprinting work in that case was somewhat fraudulent. Like the expert kind of knew that it wasn't a match, basically. It was pretty good evidence. Like the person fleeing after a shooting of a police officer, like grabs a glass of water. And so that was like a really good surface to get a good print, has a nice sip, and then runs out of the house or whatever. And basically, like the crime lab examiner presents the evidence in a highly misleading way to disguise the fact that he saw differences and knew it wasn't the guy's print. The defense hires their own expert who gets the markups that were misleading from the crime lab expert, looks at the prints and said, oh yeah, it matches your client, defense lawyer. And so it was an independent defense expert, but they were biased by the flawed work that the crime lab did, and they came to the same conclusion. That happened to the Brandon Mayfield case too. There are 3 FBI agents who all said it matches Brandon Mayfield. The defense looked at it and said, oh yeah, they're right. They're right. It's totally your print. And it wasn't, right? He'd never been to Spain. And so when you have work that's done in this circular, biased way, even having an independent expert's a problem unless you fix the way that these techniques operate and the mindset of people using them.
I think this is a good place for me to plug in also that, we've been talking about individual cases and, the Rule 706 that I've certainly never seen. And we're talking about judges as gatekeepers. That's in individual cases. But there are sort of more systemic things. And as an example, as a possibility, and we don't know exactly what it will do, but Massachusetts now has a forensic science oversight board that is, it functions similarly in some ways to forensic science commissions in other places, although it's pretty new. And what's great about that is that it includes scientists, it includes lawyers, it includes Judge Gertner, as you mentioned, Brandon, and it includes people who outside of the courtroom on an individual case, they can actually evaluate the reliability of different techniques, and then they can make recommendations. And that allows for a few things. One, it changes the landscape, so it's not dependent on lawyers and their proficiency or judges and their courage. And it's also not dependent on someone going to trial, because as we know, more than 90% of cases, there are people who plead guilty. And if there is forensic evidence that is flawed against them, they're still going to plead guilty for the most part, because that's how the system functions. So that's the levels of coercion in the system. And so we need something outside of depending on trial, people who are going to challenge their cases, stay in pretrial detention while they challenge their cases, and they're up against, a forensic lab. We need something outside of that. And so I think, at least in Massachusetts, the Forensic Science Oversight Board has the possibility, whether it's going to function this way or not, and actually come out with these recommendations. And then what the judiciary and lawyers do about this is another question. But we're right at the beginning of that, and there's at least some possibility. This would be a great book to send to everybody on the Forensic Science Oversight Board so they can start looking at this.
All right, we have time for, let's do 2 more. We have a question and comment from Mike Bowers. He says he knew bite marks would be first. Also, he asks if you could talk about the resistance within FS to admit the non-science origins needed to be stress tested, i.e. ballistics.
Oh, thank you for joining us, Mike. And he's been a really important advocate for reason in forensics, and particularly within the forensic odontology bite mark community. You know, I understand why people don't like to be tested in their jobs, and why people who have a great deal of training and experience don't like to be told that they're not the experts that they think they are. You know, I teach at a law school. Like we're producing students who get jobs based on their credentials. I think there's a difference in law where we don't claim to produce accuracy in our answers. We're not a scientific profession. We're, I think, transparent that, look, my judgment is like, you have a pretty good claim. We'll see what happens in court. We try to provide the best judgment we can, but we try to be very clear about what the boundaries are. I think that, you know, most professions are like that. And in the past, forensics weren't. And people would just say, they wouldn't say, like, my judgment is this is a high quality print, and I think there's a lot of information here, and there are a lot of connections between these prints. But look, I can't tell you whether 100 or 1,000,000 or 1,000 other people could also leave a latent print like this, because we don't have statistics. Like, that would be a more honest answer. It's very, you know, there's much more of a charge going into the courtroom and saying, I'm infallible. There's 100% certainty that this person left the marking. It's more exciting. It's more dramatic. Prosecutors were pushing for that kind of testimony, and continue to do so. And so then all of a sudden there's this culture. You know, some of my fingerprint community friends have talked about the culture of making a call, and you're a wimp if you're not making the call. And that's your job, is to make the call. You know, call a hit or don't say anything at all. And I really think that it will strengthen these professions to be more careful about strengths and limits. And there are some forensics that actually people are somewhat skeptical of, because they may sound made up, they may be less familiar. And when you support the work with research, like, people may place more weight on some forensic that they're skeptical of when they hear about the research. They'll place less weight on others. But the other important point is that a lot of lawyers getting a one-page report, they don't know what to make of it. A lot of lawyers are actually much more skeptical than jurors are of forensics, because they do read this stuff. And plenty of lawyers don't place so much weight on forensics, particularly over the last 10 years. They need to know whether it's a strong match or a weak one, and they're not given that kind of probabilistic information. As lawyers, we tend to understand that all evidence is probabilistic. There are strong witnesses, there are weak witnesses. We kind of get it intuitively. And when you get these one-page reports saying the bullets were identified or whatever, that doesn't tell you what you need to know. And most cases are pleaded out. And so we need to be giving decision makers more meaningful information. And I think that culture change will hopefully actually improve what lawyers do, and improve communication between lawyers and jurors and forensic examiners. But you know, we will see what happens over time. It's been really slow.
All right. I think we have time for one more. Oh, Daniel, did you have one more thing to say?
Oh, well, I don't want to distract from things, Audrey, but just very briefly, I think the aversion to cognitive dissonance is a big part of this too, which is that a lot of forensic scientists think they're wearing the white hat and they're on the side of justice, the side of the angels. And then when they hear about some of the flaws in their discipline, they take it very personally. And many of us just can't grapple with any type of cognitive dissonance. We like to think of ourselves as good people who are doing good things. And when we are confronted with the reality that we're not so good, we tend to downplay that data and downplay that significance. So I think a lot of it is the manner of presenting these flaws to people in sort of a non-threatening way, and presenting it not as a personal attack, but as more of a systemic issue, like Radha mentioned. Thanks, Audrey.
Yeah, absolutely. I really wish we could keep going, but I'm going to ask one more question. This is from David. He asks, is there something fundamentally flawed about having a trial judge be the gatekeeper to forensic evidence under Daubert? Is there a better procedure you'd recommend to vet reliability?
Yeah, it should be regulated, right? It should be like clinical laboratories. where you don't just like leave it up to each hospital to say, oh yeah, we'll just pick the people we think are good at screening for cancer and we'll just let them do what they want to do. Any laboratory, any medical facility that gets any kind of federal funding is subject to detailed regulations. There are serious testing protocols. It should, crime labs should be like real labs. They should be like clinical labs, and they should have to meet serious quality control standards. I mean, the National Academy of Sciences called for the creation of a federal agency. It should be like the FDA. It should be like a regulated industry where there are national rules, and it's not just left up to each police department or state. And there are a handful of states that have forensic science commissions, but they can't. Why should it be state by state, right? It's not like in Massachusetts, there's like a different research about how to handle, ballistics evidence that's relevant, and that it just doesn't need to work the same way in Oklahoma, right? There should be national standards, and it's more efficient. It would save a lot of money, be a drop in the butt. I talked about some of the funding issues. There's a lot of federal funding that mostly goes towards the federal interest in putting more stuff in giant federal data banks. If we spent just a fraction of that on quality and on setting up a national regulatory body, it would improve the work of labs around the country. It would support their work. And instead, we have like sort of these quasi-professional associations coming up with internal standards in certain communities. We have some more research funding, which is good, but we don't have serious regulation. We shouldn't be leaving it up to judges. We shouldn't be leaving it up to lawyers, and we certainly shouldn't be leaving it up to jurors. There should be national standards. I can't imagine like if it was just like, just decide for yourself, what vaccines you should take or what vaccines not to take. Like there's a reason we have the CDC and we have the FDA doing drug approvals, and that there's a national approach towards national problems. This is a national problem.
Any final words from anyone else before we close?
Thank you for having us.
Yeah, thank you so much. It's great to be back at the Harvard Bookstore, and I hope for those of you who are new to these issues that you still get entertained when you watch CSI type shows, but that you think more skeptically about all the ways that this evidence, which seems so powerful, could go wrong. This evidence is really important. We really want good forensics to solve crimes. We don't want to be relying on other evidence I've written about, like the eyewitnesses or police interrogations. Like crime labs are important. We want them to be good. And so this is not to trash a really, really important profession in this country, because it's a really important profession in this country, and they need the support, they need the credibility, but they also need the regulation that comes with that. And I hope that in future years, we start to see more progress.
Thank you all so much for your time and coming and speaking with us today. And thank you just for the work you're doing and the amount of labor you're taking to make this country better, to improve the criminal justice system and all its flaws. And thank you to everyone at home who's tuning in tonight. I'm sorry we didn't get through all of your questions. There were a lot of them. We just don't have time. I'm really sorry. But thank you so much for showing up in support of independent bookselling, publishers. And if you would like to support Brandon, check the link in the chat to purchase Autopsy of a Crime Lab. We sincerely appreciate your support now and always. From all of us at Harvard Bookstore, stay safe and be well. Take care.